What's going on YouTube? Listen up, young elder gang. This is billionaire Ted Strokes at you with another banger. This is Class 2 of the Roman law system. If you haven't checked out Class 1, be sure to check out Class 1 just below this video on the video side. Please make sure you like, subscribe, and share this video, fam. I hope this video get at least 100,000 likes. In this video, you will find history, definitions, scripture, information, and best of all, what we Americans have been deprived of from the beginning, the truth. Keep in mind, this content used in this video is intended for entertainment, educational, and informational purposes only. The information provided on this video is not to be construed as legal advice. We are not legal attorneys. For legal advice, please seek out a licensed legal advisor or attorney. We will give you the total truth as we best understand it today. Be sure to hit that like button, young elder gang. Hit that subscribe button if you're new to the channel. Hit that bell and don't forget to check back with us every day for new content. In this video, we will touch more on Roman law terminology. Alright, let's get started. The natural law tradition emerged in the 17th and 18th centuries, but its roots can be traced back to ancient Greece and Rome. The modern theory of natural law was influenced by Roman law, Christian scholastic philosophy, and social contract theory. Natural law is a system of law based on a close observation of natural order and human nature, from which values, thought by natural law's proponents to be intrinsic to human nature, can be deduced and applied independently of positive law. Natural law is an ethical theory that claims that humans are born with a certain moral compass that guides behaviors. These inherited rules essentially distinguish the rights and wrongs in life. Under natural law, everyone is afforded the same rights, such as the right to live and the right to happiness. What are the two basic principles of natural law theory? Natural law theory is concerned with two basic principles, morality and legality. Morality in natural law is concerned with the perceived objective, universal laws that define and guide human moral behaviors. Generally speaking, this school of thought is the opposite of natural law. Legal positivism proposes that there isn't necessarily a connection between law and morality. Aquinas' natural law theory contains four different types of law: eternal law, natural law, human law, and divine law. The way to understand these four laws and how they relate to one another is via the eternal law, so we'd better start there. By eternal law, Aquinas means God's rational purpose and plan for all things. And because the eternal law is part of God's mind, then it is always and will always exist. The eternal law is not simply something that God decided at some point to write. Aquinas thinks that everything has a purpose and follows a plan. He, like Aristotle, is a teleologist. The Greek term telos refers to what we might call a purpose, goal, end, or the true final function of an object. Aquinas thinks that something is good in as far as it fulfills its purpose plan. This fits with common sense. A good eye is one which sees well. An acorn is a good acorn if it grows into a strong oak tree. We will go in more on the Aquinas in another tape. Natural law theory can also refer to theories of ethics, theories of politics, theories of civil law, and theories of religious morality. In Western tradition, natural law was anticipated by the pre-Socratics, for example, in their search for principles that governed the cosmos and human beings. The concept of natural law was documented in ancient Greek philosophy, including Aristotle, and was mentioned in ancient Roman philosophy by Cicero. References to it are also found in the Old and New Testaments of the Bible and were later expounded upon in the Middle Ages by Christian philosophers such as Albert the Great and Thomas Aquinas. The school of Salamanca made notable contributions during the Renaissance. Although the central ideas of natural law had been part of Christian thought since the Roman Empire, its foundation as a consistent system was laid by Aquinas, who synthesized and condensed his predecessor's ideas into his Lex Naturalis, lit. Natural law. Aquinas argues that because human beings have reason, and because reason is a spark of the divine, all human lives are sacred and of infinite value compared to any other created object, meaning everyone is fundamentally equal and bestowed with an intrinsic basic set of rights that no one can remove. Administrative law is a branch of public law that governs how the government implements and enforces laws. It's concerned with the creation and operation of administrative agencies, including the powers they have, the rules they make, and their relationships with other government bodies and the public. Administrative law is important because it ensures that the government operates in a just, economical, and efficient manner. It also helps to uphold core political and social values. Administrative law is a significant component of agricultural law. The United States Department of Agriculture and the Environmental Protection Agency are two examples of administrative bodies that play a major role in regulating the agricultural sector. Criminal law is a system of laws that defines crimes and the punishments for those who commit them. It also establishes the rules and procedures that apply when the police investigate a crime, the prosecuting authorities charge someone, and the accused appears in court. Criminal law is a fundamental part of the legal system, and it plays a key role in upholding justice and protecting society. It sets boundaries on acceptable conduct and aims to ensure public safety. It prescribes conduct perceived as threatening, harmful, or otherwise endangering to the property, health, safety, and welfare of people inclusive of oneself. Criminal law differs from civil law, which usually involves disputes between people or organizations. In a criminal prosecution, the government decides whether to punish an individual for an act or omission. Here are some common types of crimes and their penalties. Felonies, serious crimes like murder, rape, and arson that usually result in more than a year in prison. Misdemeanors, less severe offenses like petty theft or simple assault that often result in fines, probation, or less than a year in jail, strict liability offenses. Acts like traffic violations, where committing the act is enough to be guilty, regardless of intent. In the United States, each state and the federal government have their own criminal codes, which define specific crimes and their degrees. The penalties for each degree of crime vary by jurisdiction. Contract law is the legal framework that governs agreements between parties that create obligations to perform or not perform a specific duty. A contract is an agreement that specifies certain legally enforceable rights and obligations pertaining to two or more parties. A contract typically involves consent to transfer of goods, services, money, or promise to transfer any of those at a future date. Contracts can be verbal or written and can be for simple tasks or complex trade mergers. Contract law ensures that agreements are legally binding and enforceable. It considers questions such as whether a contract exists, what the meaning of the contract is, whether a contract has been broken, what compensation is due to the injured party. A contract is legally enforceable if it contains the following elements. Offer, one party makes an offer for goods or services. Acceptance, the other party accepts the offer. Mutual consideration, there is a bargain for exchange of value to benefit both parties. Capacity, all parties are mentally and legally able to agree to the terms of the agreement. If one party breaches a contract, the other party can sue for compensatory damages. The wronged party can tally up the value of what they've lost and sue to have the breaching party compensate them for those losses. Contract law is different from tort law, which deals with private duties and obligations that exist by operation of law. Civil law, also known as private law, is a branch of law that governs the legal relationships between individuals and entities, such as companies. Civil law is a legal system originating in Italy and France that has been adopted in large parts of the world. Modern civil law stems mainly from the Napoleonic Code of the early 19th century, and it is a continuation of ancient Roman law. It deals with non-criminal matters such as contracts, property, personal injury, and family law. Civil law systems are based on Roman law, canon law, and local customs, and are the most common legal system in the world. They are characterized by broad codes and detailed statutes that determine the rights and obligations of individuals. In civil law countries, judges are primarily responsible for finding facts and applying the law. Civil law is different from criminal law, which deals with matters between individuals and the state. It is also different from common law, which places more emphasis on the role of precedent, courts, judges, and juries. Constitutional law is the study of the interpretation and application of a country's constitution, including the rights it protects and the structure of its government. In the United States, constitutional law covers the federal and state constitutions and includes rights. The rights protected by the Constitution, such as the right to vote, freedom of speech, and freedom of the press, the structure of the federal and state governments, including the separation of powers between the executive, legislative, and judicial branches' relationship between governments. The relationship between the federal government and the state governments. Judicial review, the power of the Supreme Court to declare actions of the government unconstitutional. Constitutional law is often based on rulings from the state and federal Supreme Courts, which ensure that laws passed by the legislature don't violate the Constitution. International law is a set of rules and principles that govern the conduct of states, international organizations, and individuals. It's also known as public international law or the law of nations. The goal of international law is to promote peace and order between nations. It applies to a wide range of issues, including human rights, disarmament, international crime, refugees, migration, the environment, sustainable development, international waters, outer space, and global communications. International law differs from domestic legal systems because it's largely based on consent. There's no universally accepted authority to enforce international law on sovereign states. However, states and non-state actors can face disapproval or coercive action for violating international law. Some sources of international law include international custom, treaties, and general principles of law recognized by most national legal systems. One example of international law is international humanitarian law, IHL, which limits the effects of armed conflict. IHL lays out the responsibilities of states and non-state armed groups during armed conflict. The Geneva Conventions of 1949 are among the most important treaties that enshrine the principle that wars have limits. Equality before the law is the principle that all people should be treated equally by the law, regardless of their status or attributes. It's a fundamental tenet of a fair and just legal system and is a key component of many constitutions. Equality before the law requires that. Laws and policies are applied equally and without discrimination. Public entities, courts, and tribunals treat all people equally. Laws provide equal protection for everyone. The rule of law is observed and due process is followed. The 14th Amendment to the U.S. Constitution granted all citizens equal protection under the laws. The Equal Protection Clause guarantees that people who are similarly situated will be treated the same by the law. The phrase, equal justice under law, appears over the entrance to the Supreme Court building. Equality before the law, also known as equality under the law, equality in the eyes of the law, legal equality, or legal egalitarianism, is the principle that all people must be equally protected by the law. The concept of equal under the law is pretty straightforward. It means that regardless of race or color, political views, sex, religion, or other characteristics, justice is blind and everyone is treated the same and equally under the law. Fairness in the application of the law means that the legal system should treat everyone equally, without bias or favoritism, ensuring that the rules and procedures are applied consistently to all individuals regardless of their personal characteristics, like race, gender, socioeconomic status, or other irrelevant factors. Essentially, it signifies the principle of equal justice under the law. Impartiality judges and legal officials should make decisions based solely on the facts of the case, not personal opinions or prejudices. Due process. Individuals should be afforded the right to a fair legal process, including the opportunity to present evidence, confront witnesses, and be represented by counsel. Consistency. Similar cases should be treated similarly, with rulings following established legal precedent. Transparency. The reasoning behind legal decisions should be clear and understandable to the public. Challenges to fairness in law application. Implicit bias. Unconscious biases held by legal professionals can affect their decision-making. Socioeconomic disparities. Unequal access to legal representation can disadvantage individuals with limited means. Discriminatory laws or practices. Laws that disproportionately impact certain groups based on protected characteristics. Other laws are family law is an area of the law that deals with family matters and domestic relations. Commercial law, which is also known by other names such as mercantile law or trade law depending on jurisdiction, is the body of law that applies to the rights, relations, and conduct of persons and organizations engaged in commercial and business activities. Labor laws, labor code, or employment laws are those that mediate the relationship between workers, employing entities, trade unions, and the government. Collective labor law relates to the tripartite relationship between employee, employer, and union. Property law is the area of law that governs the various forms of ownership in real property and personal property. Property refers to legally protected claims to resources, such as land and personal property, including intellectual property. Corporate law is the body of law governing the rights, relations, and conduct of persons, companies, organizations, and businesses. The term refers to the legal practice of law relating to corporations, or to the theory of corporations. Real estate is property consisting of land and the buildings on it, along with its natural resources such as growing crops, minerals or water, and wild animals, immovable property of this nature. An interest vested in this an item of real property, buildings or housing in general. Immigration law includes the national statutes, regulations, and legal precedents governing immigration into and deportation from a country. Strictly speaking, it is distinct from other matters such as naturalization and citizenship, although they are sometimes conflated. Tax law or revenue law is an area of legal study in which public or sanctioned authorities, such as federal, state, and municipal governments, use a body of rules and procedures to assess and collect taxes in a legal context. Environmental laws are laws that protect the environment. Environmental law is the collection of laws, regulations, agreements, and common law that governs how humans interact with their environment. The separation of powers principle functionally differentiates several types of state power and requires these operations of government to be conceptually and institutionally distinguishable and articulated, thereby maintaining the integrity of each. Separation of powers is a principle that divides the responsibilities of a government into separate branches to prevent any one branch from becoming too powerful. The goal is to create a system of checks and balances that ensures each branch has its own role and authority, but also depends on the other branches to function. In the United States, the Constitution establishes 3 branches of government. Legislative makes laws and appropriates money. Executive enforces laws and implements public policy. Judicial interprets laws and the Constitution. Some examples of how the separation of powers works in the U.S. include impeachment. The House of Representatives can bring impeachment charges against the President, and the Senate can convict and remove the President from office. Appointments. The President appoints Supreme Court candidates, and the Senate confirms them. Advice and consent. The Senate has the power to confirm presidential nominations, which gives it influence over the composition of the executive and judicial branches. Participative decision-making is the extent to which employers allow or encourage employees to share or participate in organizational decision-making. According to Cotton et al., the format of PDM could be formal or informal. Participation in decision-making, PDM, is the practice of involving people in the process of making decisions, whether it's in an organization, community, or government. PDM can be formal or informal, and can involve a variety of activities such as, in the workplace, employees can share their ideas and expertise to help the organization meet its goals. This can lead to benefits like improved morale, increased productivity, and a more positive attitude among employees. In the community can be engaged to inform and legitimize the decision-making process. This can build trust and confidence in the decision-makers and the decision process. In government, governments can consult with indigenous peoples when a decision may affect them in ways that it doesn't affect others. This can involve ensuring that consultation processes are framed to build consensus and that free, prior, and informed consent is obtained. Some activities that can be part of public participation include town hall meetings, advisory committees, citizens' assemblies, opinion polls, participatory design, participatory budgeting, referendums, protests, and votes. Legal certainty is a principle in national and international law which holds that the law must provide those subject to it with the ability to regulate their conduct. Legal certainty is a principle that ensures citizens can know the law and the legal consequences of their actions. It's a fundamental part of the rule of law and is important for a number of reasons, including predictability. Citizens should be able to plan their actions based on clear and precise legal provisions. Fairness. Legal certainty guarantees equal and impartial treatment and limits the power of administrative authorities. Economic efficiency. Clear legal provisions can reduce transaction costs and promote efficient business. Some other aspects of legal certainty include consistency. Citizens should be able to rely on consistent regulations and administrative practices. Non-retroactivity. Legal and regulatory provisions shouldn't be applied retroactively. Access to justice. Legal certainty is improved when access to justice is improved, and vice versa. Court decisions. Once a court decision has entered into force, it can't be called into question. One of the main elements of the rule of law is the principle of legal certainty, which provides inter alia that in any dispute, a court decision that has entered into force cannot be called into question. Certainty in contract law refers to the clarity and precision of the terms and conditions within a contractual agreement. All parties involved in a contract need to fully understand and interpret its terms. A contract should be a complete and final agreement, leaving no room for ambiguity or misunderstanding. Avoidance of arbitrariness is the principle of making decisions based on reason, consistency, order, and predictability, as opposed to whim or caprice. It's a core element of the rule of law, which requires that laws are applied fairly and equitably, and that people are accountable to them. Arbitrariness is the opposite of avoidance of arbitrariness, and is characterized by unpredictable, random, and unreasonable actions. For example, if someone is given detention for not eating peaches one day, not wearing a top hat the next, and walking backward the third day, that would be considered arbitrary. The rule of law requires that the law is known and predictable so that people can understand the consequences of their actions. It also requires that the government's discretion is limited so that the law is applied in a non-arbitrary way. Principle of avoiding arbitrariness, PAA. For all propositions X, if X is warranted for a person S at T, then there is some reason 1 real available to S for X at T, and there is some reason 2 reals available to S for 1 real at T, etc., and there is no last reason in the series. Example: a judge sentences a person to jail for 10 years for stealing a candy bar. This decision would be considered arbitrary because it's not a fair application of the law. The punishment doesn't fit the crime. In semiotics, the general theory of signs, sign systems, and sign processes, Saussure introduced the notion of arbitrariness according to which there is no necessary connection between the material sign, or signifier, and the entity it refers to or denotes as its meaning, or signified, as a mental concept or real. Something is morally right because it is commanded. If this is true, God could command anything, even genocide, and it would be morally right. This is known as the arbitrariness problem. An important motivation for uniqueness is the so-called arbitrariness argument. It says that learning that one is in a permissive case would result in some unacceptable arbitrariness with regard to one's doxastic attitude. White, 2005. Economic development is the process of improving a community's economic well-being and quality of life through policies, programs, and activities. Government policies. These include policies to control inflation, promote high employment, and ensure sustainable growth. Services. These include building highways, managing parks, and providing medical access. Business, climate. These include policies and programs to improve the business climate through business finance, marketing, and real estate development. Community assets. These include developing or improving community assets that businesses need to succeed. Economic resilience. This includes the ability to recover quickly from a shock, withstand a shock, and avoid the shock altogether. Economic development is more than just a jobs program, and it's important for the well-being of the population. It involves allocating resources, intervening in economic growth, and influencing private sector investment. Economic development practitioners work in public offices or in public-private partnerships organizations. They provide leadership in policy making and administer policy, programs, and projects. Personality, the law of the state only applied to citizens, and foreigners had no rights. Paternal power. The head of the family had sole authority and represented the family in state tribunals. Sons could not marry or hold their father's property until they reached majority age and received their father's consent. Written laws. The Roman legal system emphasized the importance of written laws and legal expertise. Jus gentium, the law of nations, which aimed to create a universal legal system for all people. Stare decisis, the principle of standing by things decided, which laid the groundwork for precedent in modern legal systems. The principle of standing by things decided, which laid the groundwork for precedent in modern legal systems. Interest theory, the division of law into public and private law based on the interest of the state versus individuals. Quasi-delict, a group of harms that included actions against occupiers for harm caused by things thrown from their house, and actions against innkeepers, shipowners, or stable-keepers for loss caused by theft or damage. Quasi-contract, a group of obligations that did not fall under contract or delict, such as when someone intervened in another's affairs for their benefit and claimed reimbursement. Roman law influenced the legal systems of many countries, including France, Germany, Italy, and Spain. Today, countries with civil law systems, such as France, Germany, and Italy, have legal systems that are directly based on Roman